Welcome to International Trade Minute Quickfire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm. This podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify and join our professional community on LinkedIn. In today's episode, we're covering significant developments across the trade landscape, Biden's blockage of Nippon Steel's U.S. steel acquisition and the ensuing legal battle, Oracle's stark criticism of upcoming AI export controls, the GAO's call for increased FDA oversight of foreign food facilities, a major False Claims Act case dismissal involving Amazon, and an important CBP ruling on Corning's fiber optic cables. Let's dive in. We are starting with a major development for international trade. President Biden has blocked Nippon Steel's $14.9 billion acquisition of U.S. steel, citing national security concerns. This January 3rd decision followed nearly 10 months of review by the Committee on Foreign Investment in the U.S., CFIUS. The administration emphasized the importance of keeping U.S. Steel, a 124-year-old company, under domestic control to safeguard national interests. Nippon Steel has challenged the decision, filing a lawsuit with U.S. Steel in the U.S. Court of Appeals, claiming the move violates due process and CFIUS regulations. What's particularly noteworthy for trade practitioners is Nippon Steel's assertion that they proposed substantial commitments to address security concerns. These included ensuring U.S. citizenship for key executive positions, establishing CFIUS-approved independent directors, and guaranteeing no transfer of production or jobs outside the United States. According to Nippon Steel, these proposals received no written feedback during the 100-day review period. The United Steelworkers Union, led by President David McCall, has backed the administration's decision, maintaining that both companies had ample opportunity to address concerns. Meanwhile, congressional reactions have split along expected lines, with acquisition opponents praising the protection of American jobs, while supporters argue the decision could hamper U.S. Steel's ability to modernize and compete effectively. For trade practitioners, this case presents a critical precedent in how CFIUS reviews are conducted and the extent of presidential authority in blocking foreign acquisitions. It also raises important questions about the treatment of investments from allied nations and the broader implications for foreign direct investment in critical U.S. industries. The outcome of Nippon Steel's legal challenge could significantly influence future cross-border acquisitions in sensitive sectors. Most concerning for international trade relationships is Nippon Steel's warning that this decision could send a chilling message to other companies from allied nations considering U.S. investments. This situation underscores the delicate balance between protecting national security interests and maintaining open investment policies with key allies. Moving on, Oracle has raised alarms over the Bureau of Industry and Security's proposed AI export control rule, calling it potentially one of the most damaging regulations for the U.S. tech sector. The rule, spanning 200 pages, would impose global licensing requirements on certain AI technologies and U.S. origin GPUs, impacting industries like cloud computing and semiconductors. Critics argue its broad scope risks undermining U.S. leadership in these fields. Key provisions include a new group of 20 AI authorization countries facing strict certification and reporting rules, and universal validated end users whose stringent audit and localization requirements may limit practical applicability for most global data centers. For trade practitioners, the most pressing concern is the rule's potential to push international markets toward Chinese technology. Oracle warns that other countries might simply abandon U.S. origin technologies rather than navigate the complex licensing requirements. The proposed 60-day delayed effective date is viewed as inadequate for an industry-wide transformation of this magnitude. The rule's global scope represents a significant departure from traditional export controls that typically target specific countries like China and other arms embargoed regions. Trade professionals should note that this broader approach could fundamentally alter the economics of data center deployment globally and potentially fragment the international AI technology market. Oracle's criticism extends to the rulemaking process itself, pointing out insufficient industry consultation and questioning the timing of its release just before a presidential administration change. For trade practitioners, this highlights the critical need to prepare for potentially significant shifts in technology, export compliance requirements, and to closely monitor developments in this rapidly evolving regulatory landscape. Next up, the Government Accountability Office has released a critical report highlighting significant gaps in the FDA's oversight of imported food safety. According to the findings, approximately 15% of the U.S. food supply is imported, including 32% of fresh vegetables, 55% of fresh fruit, and a striking 94% of seafood consumed by Americans. The GAO's assessment reveals a concerning disparity between the FDA's inspection capabilities and the vast scope of foreign food facilities requiring oversight. While the FDA maintains an annual target of 4,695 foreign facility inspections, they project being able to conduct only 1,008 inspections in fiscal year 2024 due to resource constraints. This shortfall becomes even more significant when considering the scale of operations. There are approximately 125,000 foreign food facilities subject to FDA inspection, with about 12,400 currently on the agency's Import Alert Red List. Facilities on this list face potential refusal of their products at U.S. ports of entry. The GAO report specifically calls on Congress to direct the FDA to analyze and determine the appropriate level of foreign food facility inspections needed annually to ensure imported food safety. Additionally, the report recommends that the FDA commissioner assess the proper size and workload requirements for its foreign investigator workforce. For trade practitioners, it's particularly noteworthy that foreign facility inspections typically require advance notice, unlike domestic inspections, due to their more complex planning requirements and higher costs. Facilities that fail to respond to inspection notices risk placement on the Import Alert Red List, potentially blocking their products from entering the U.S. market. The GAO has also recommended establishing new performance measures in collaboration with the Centers for Disease Control and Prevention to better evaluate the impact of food safety inspections on imported food security. These metrics would help determine whether current inspection practices effectively protect public health and facilitate informed decision-making about resource allocation. We continue with a key ruling Judge Edgardo Ramos of the Southern District of New York dismissed a False Claims Act lawsuit against Amazon involving alleged tariff evasion on fur product imports. The case, filed by Hennig Furs, accused Amazon of conspiring with Chinese manufacturers to undervalue and mislabel shipments to avoid duties and bypass wildlife import regulations. However, the court found insufficient evidence to prove Amazon knowingly violated the FCA or willfully ignored the alleged scheme, deeming general profit motives inadequate to establish liability. Notably, the court rejected Hennig's conspiracy claims, stating that merely pointing to ongoing business relationships and profits wasn't enough to establish a conspiracy to defraud the government. However, the court did side with Hennig on one point, determining that Amazon wasn't exempt from government payment obligations merely because Chinese exporters were listed as importers of record. For trade practitioners, this ruling underscores the high bar for proving FCA violations in import cases, particularly regarding the knowledge requirement. It also highlights the distinction between routine business operations and actual evidence of conspiracy to evade customs obligations. For our concluding piece, in a notable customs ruling, CBP has determined that Corning Optical Communications fiber optic cables are of French origin, exempting them from Section 301 duties. Although parts of the manufacturing process, such as jacketing and assembly, occur in China, CBP ruled that the critical development of fiber attenuation properties in France establishes the country of origin. The decision reaffirmed that Chinese operations, including bundling and coloring, do not constitute substantial transformation, as the optical fiber remains functional when exported from France. This precedent highlights the importance of determining origin based on essential manufacturing processes. Beyond the origin determination, CBP also revised the product's tariff classification. The agency agreed with Corning's position that the cables should be classified under subheading 8544.7 ZAR rather than 9001 10 ZAR, based on the individually sheathed nature of the optical fibers. For trade practitioners, this ruling offers valuable guidance on substantial transformation analysis in complex manufacturing processes. It demonstrates that secondary manufacturing operations, even when significant, may not constitute substantial transformation if they don't fundamentally alter the product's essential characteristics or capabilities. The decision also provides a clear precedent for similar fiber optic product classifications and origin determinations. Thanks for tuning in to International Trade Minute. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.